My name's Amanda Attrell and I head up Brixton K's award-winning Later Life team.
And I'm Wendy Pawlak. I'm one of the Later Life team assistants. Our team helps people to plan for later life, which includes helping people to manage their affairs when they are no longer capable of doing so, or remain capable but have decided that they need some help.
Well, the first option is making a document called a lasting power of attorney. They're often referred to as LPAs. And in that document, you decide who you want to act for you and on what terms in the future. They have to be registered with the Office of the Public Guardian before they can be used.
The second method is used when a person loses mental capacity and they do not have a power of attorney in place. This is known as a deputyship order.
There's been a lot of focus on lasting powers of attorney in the media recently, and that was sparked by comments made by a retired senior judge. Senior Judge Denzil Lush worked in the Court of Protection for 20 years, and over that time he will have seen thousands of cases where financial abuse did occur. He commented that he would never make a lasting power of attorney for that reason, and he felt that the deputyship route offered more safeguards to vulnerable people.
However, around 2.5 million LPAs have been registered in England and Wales over the past 10 years, and figures suggest that abuse occurs around 4% of the time, which would indicate that the majority of the time lasting powers of attorney are working perfectly well.
There's likely to come a time in all of our lives when we or someone that we care about needs some help day-to-day managing their finances. And while stories about financial abuse are worrying, we would still strongly recommend that people make a lasting power of attorney.
We work with clients on both sides of the coin, so we get to see firsthand why having an LPA is preferable to relying on the deputyship process. Here are our top 5 reasons why we would choose to make an LPA.
First reason is cost. LPAs are a lot cheaper to prepare than a deputyship order. The court fee alone is £82 compared to £400, and with the deputyship order there are annual supervision and bond fees to pay as well.
It will usually take at least 6 months to obtain a deputyship order. LPAs will take around 3 months to prepare and register, but because these are prepared in advance, they are ready to be used as soon as assistance is needed.
When making a lasting power of attorney, you get to decide who acts for you and on what terms. With a deputyship order, anyone can apply, so that could be a close friend or relative, but in some circumstances it may not be who you would have chosen for yourself. It's also possible that a professional you've never met can be appointed to act for you.
The LPA process is relatively straightforward in comparison to the deputyship process, and if you have complex financial affairs, for example if you own property or a business, then the basic authority given to a deputy may not be sufficient and further orders may be needed. This can incur further cost and delays.
People don't just need help when they lose their mental capacity, they might have physical incapacities that mean that they need assistance as well. So for example, someone may have a stroke, or they may have other mobility issues, or they might just struggle to hear someone talking on the telephone. The trouble with a deputyship order is that someone has to have lost their capacity before you can apply for it, so it just doesn't cover all cases. We agree with Senior Judge Lush that lasting powers of attorney can be open to abuse, and there are risks involved, which is why it's important to get professional advice to find out what they are and what safeguards you can put in place.
If you would like to learn more about lasting powers of attorney, the Court of Protection or other ways that you can plan for later life, then do get in touch with the Later Life team and we will be more than happy to discuss your options with you.